So good morning again, everybody. Thank you very much. Please be seated. And when the live stream is ready, go ahead and pull the case.
Good morning, Your Honors. The matter before the court today is the case entitled Ditech Financial LLC versus Karen Brisson, aka Karen Curavoo et al. Representing the appellant, Ditech Financial LLC, is Sheldon Katz. Appellee Karen Brisson is self-represented.
Okay, thank you very much, and good morning, everybody. For the benefit of counsel and the appellee who's here in person, we have with us in the courtroom this morning young fellows from Boise State. Boise State is operation that happens every summer. Judge Charles Romeo back there has for years now been very, very good about bringing Boise State here to visit us in the court. Girls State was here earlier. I don't know what happened to them, but hopefully they're coming back. We will miss them otherwise. So counsel, come on up to the podium if you would, please. And for the record, before you start, introduce yourself and your client.
Yes, thank you, Mr. Chief Justice. May it please the court. My name is Sheldon Katz.
Thank you.
I represent the plaintiff below, the appellant on appeal, Ditech Financial LLC.
Thanks very much.
Thank you, Your Honor. So this case has its roots going back to 2013. There was a mortgage and there was a default on the mortgage in 2013. There was notice given of a default. The default was not cured. And in 2015, a foreclosure was filed. In 2018, the case went to trial before Judge Tour. At the trial, the defendant, the mortgagor, denied the mortgage documents, but Judge Tour found that it was plain that the documents that were presented at trial were the documents that that supported the loan, the note, and the mortgage. There was a 6-month redemption period. At the end of the 6-month redemption period, a notice of sale was given, and the redemption period was 6 months. At the notice of sale was given, and 3 days before the scheduled sale, the defendant below filed a Chapter 7 bankruptcy. And I'm not sure if you're familiar, Your Honors, with the procedure in the Superior Court, but what happens at that time then is that the plaintiff usually.
Well, notice of bankruptcy is filed in the court, right?
Yes, we give notice.
Right.
And then the court dismisses the case without prejudice, so
Right,
that it can
right.
be reinstated once the bankruptcy docket is closed.
And you did
So-
that. You did that, right, Mr. Katz? You reopened the case after the bankruptcy petition was discharged by the bankruptcy court.
Yes,
And then the case started, then the case was going on again.
it was reinstated, yes.
So is that how we have a real party and interest issue in this case?
Well, I'm not sure that we do have a real party in interest. That was how the court phrased it, but I'm not sure what the term real party in interest really means in this context. Real party in interest is a term that is used in Rule 17 at the commencement of the case. It's never been, as far as that, and it's really limited to the commencement of the case. Sometimes during a case, especially in foreclosure, there can be a change of interest. But
we
there
do
had
have
been,
an assignment issue, don't we?
well, not an assignment of the, so there was a judgment entered. And when the bankruptcy docket was closed, the plaintiff came back to the court and said, we're ready to schedule a sale now. And the defendant brought up that the Ditech Financial LLC had itself filed a bankruptcy petition and a Chapter 11 bankruptcy petition. But in any event, Ditech continues to be holds the judgment. Now, so
But
Um,
does Ditech have the mortgage?
does Ditech have the mortgage? Well, that raises the merger doctrine because under this court's precedents and under really the precedent in probably every jurisdiction, the underlying contractor, in this case, a note, merges into the judgment. It doesn't exist anymore. Otherwise, you can enforce the judgment and you can enforce the note. It doesn't exist anymore. And the mortgage doesn't exist anymore either.
Oh, I was about to ask you that. Does the debtor have any right to reinstate the mortgage?
Yes. Well, the debtor doesn't have a right to reinstate the mortgage, but the debtor has, under the judgment, the debtor has a right to redeem anytime before sale, to redeem, meaning to
The day
pay off
before.
the entire amount due under the judgment.
To who?
Due under the judgment, not due under the mortgage, right?
Due under the judgment.
the judgment.
Yes, Your Honor.
And who do they pay?
They pay the servicer. So the
Well, wouldn't
servant,
they don't they pay the court and then the court?
the court, actually, it's paid into the court. Yes, that's correct.
So, okay, so the judgment's issued in 2018
Correct.
and the original note from 2007 had a 6.5 interest rate, correct?
Yes.
So when the judgment's ordered in 2018, how is interest calculated from that point forward?
Officially, it's calculated under the judgment. So it's 1% simple interest rate per month.
Okay,
It's common practice because the servicer doesn't, the mortgage servicer, the loan servicer, doesn't usually put on its books the judgment. So oftentimes, the servicer will allow, will not collect the 1%, but that's unofficially, but officially 1% per month is the judgment rate.
Is
And if
Ditech the servicer here?
Ditech was the servicer at
Who
the
is it
time of
now?
the judgment. The current servicer is New Res LLC, which is formerly known as New Penn Financial LLC, and it does business as ShellPoint. And ShellPoint has been servicing the note for 6 years and it is the acknowledged servicer of the note. And it's been issuing all its notices.
The note was extinguished.
I'm
at
sorry,
that
not the
judgment.
note, the judgment, excuse me.
They have been servicing the judgment?
Yes, they have.
Well, the paperwork says they're clearly servicing the mortgage. All the documents in your printed case clearly state that ShellPoint, when they kept sending notices, were all about the mortgage and the note and the 6.5 interest rate,
Yes,
way into 2024.
yes.
So how do you explain that?
How do I explain that? As I mentioned before, Judge Cohen, the judgment doesn't get reflected on the books of the servicer. So that, and actually that works to the benefit of the mortgagor.
Why?
Because, why does it do that? I think it's probably for accounting reasons.
See why
So
it-
they would accept, they may, I mean, they're not required to, but they could accept less than the judgment rate of interest. But it's not actually reflected on their books.
All right, so a follow-up question to my learned colleague. The debtor, the mortgagor comes in and during this period of time before sale and says, I want to pay this off. And they do, what they would get at that point is a satisfaction of judgment, is it not?
That's absolutely correct, Your Honor. They would not get a discharge because the mortgage doesn't exist anymore. The note doesn't exist anymore. All that exists is the mortgage. And under Vermont law, there are differences.
It's the judgment. You
It's the
said,
judgment.
The judgment,
yeah. you
excuse me.
said all
All that exists is the judgment.
Yeah.
And the judgment defines the relationship between well, it's not the mortgagee and the mortgagor anymore. It's really the judgment debtor and the creditor.
So-
To me, the real issue in this case is whether the trial court erred or did not err in granting a motion to dismiss for failure to prosecute. Can you talk a little bit about that type of motion and why, I'm assuming you think the court erred in granting that motion?
Well, yes, Your Honor, thank you. And the court definitely erred in doing so. For one thing, the failure to prosecute comes under Rule 41, which is in the trials section of the court rules. And this court actually had found in TBF versus Gregoire that the only way that a judgment of foreclosure can be vacated is under Rule 60. And that was not the way it happened. But the other thing, Your Honor, is that there was no motion to dismiss. There was no motion to dismiss the case. And under Rule 41, a dismiss of 41B2, a dismissal can only, the court can only dismiss on a motion by the defendant. There was no motion to dismiss. And as far as, so the underlying reason for the court's dismissal was this real party in interest.
Failure to prove the real party in interest.
Failure to prove the real party in interest. Now, so the real party in interest, I was a little bit puzzled when that came through from the court below, because the real party in interest is the judgment creditor. Ditech Financial LLC has a judgment. There is no other real party in interest
Well,
here.
Mr. Katz, I'm a little confused about the transactions that occurred post-judgment, where it appears that the mortgage and the note, both, were sold at least 4 times post-judgment, and I haven't seen one assignment of the judgment itself. In fact, I think in your paperwork, you say the judgment's never been assigned, but the mortgage and the note were signed 4 times after the judgment were issued. Well, doesn't that have some effect on this? So they're still selling it as it's going on, even though, and missing the fact that there was a judgment order out there. I can't seem to understand that, how that process works.
Yes, thank you, Your Honor. So there are 3 roles on the side of the mortgagee in a foreclosure, or in the mortgagee period, whether the loan is current or not. There's a servicer. The servicer is not a party to the foreclosure action. There's the note holder, but in this case, there is no note holder. There's only a judgment. And that's in the name of Ditech. And then there's an investor. Now, there are 3 roles. Sometimes those roles are played by one entity. So the same entity is the investor, holds the note, and is also servicing the note. In this case, those roles are played by different parties. So Ditech has the judgment. The current owner investor is a trust with U.S. Bank Trust as the trustee. It's called it's called BRMTG Asset Trust. And that is the current investor.
And they purchased the note in the mortgage.
Well, no, they didn't purchase the note in the mortgage
Well, how did
because
it got
because they
assigned?
purchased the right to direct the proceeds of the judgment. It'll either be paid
Not
off.
in any of the paperwork that you submitted in your printing case, there's nothing indicating that any of the owners did anything other than purchase the note and the mortgage. Nothing about the judgment that I could see.
Right. The judgment has not been assigned. So the judgment has not been assigned, but the investor has changed. And Shell Point gave notice of Shell Point as the servicer of the mortgage asset. Let's call it a mortgage asset now, because it's not a mortgage anymore. It's a judgment.
You know,
So-
you cited a case that actually I haven't read yet, but I thought was very interesting. The squib that you assigned to it, it's a 2012 Southern District of Texas case called Houston. You remember this? No, you don't. But anyway, according to your brief, it says that the beneficial ownership of a mortgage asset, that is the investor who is entitled to proceeds, has no legal relevance in the foreclosure proceedings,
That's correct.
which I think is what you're arguing here.
That's exactly what I'm arguing, Your Honor.
But it is sort of a befuddling statement. I wonder about standing, for instance, how does that come in? And I think, I don't have a question. I'm just,
Okay.
I'm just droning on
And
that.
by the way, while you were talking, before you started talking, I did remember the case, and
Oh,
that
you-
is
oh,
exactly.
oh, now you do.
So I
Okay,
get
good.
credit for that. But
It's in your brief.
it is in the
promise you
brief,
that,
yes, and
yeah.
I do recall that. Yes, that is absolutely correct, that it could be the beneficial owner without holding the paper. As I said before, there are three roles. There's the investor, the note
Yeah.
holder,
Right.
or in the case of pre-foreclosure, and the servicer. In this case, there's a judgment. It's being serviced by Shell Point, and it's the investor is this asset trust.
Right, and it's the investor here who's been, there's been transfers of who the investor is.
Well, there has been no transfer of the judgment, but that doesn't really, that's irrelevant because there's one judgment and it can be enforced in the name of Ditech. And under Rule 25C, even a change of interest does not necessarily require the plaintiff to change the name on the lawsuit.
Not
If
only
what I'm-
require the rule says that it may continue.
it may continue it.
In
And-
the original party's name.
And that's exactly what's happened right now. Now, we could, on a remand, we could do whatever the trial judge wants us to do in terms of putting it in a name, but I don't think that's necessary because under Rule 25C, we can continue to execute the judgment.
My question was a little bit more confined, I think, than that, and I was trying to get at what Justice Cohen is suggesting has happened. That was a sale of the beneficial interest. Is that
That's correct. That's correct. And Shell Point, as a servicer, gave notice because as it's required to under federal regulation, Shell Point gave notice to the judgment debtor that had happened.
So
No, go ahead, Chief.
if the investor is not a party in front of us here, am I right?
You are correct.
So if how is it that they're standing to be involved here? If the issue for standing is an actual injury to the party that is in front of us, there's no actual injury. The actual injury is to the investor, not to the party in front of us.
So we already have a judgment in place. So standing, I don't think that was
Well,
not
you're
the
looking
issue
to
that
enforce the judgment, right?
who can execute the judgment.
Execute the judgment.
Just as it always is in every foreclosure case, the servicer is acting on behalf of the interest. So the servicer will execute the judgment at the direction of the beneficiary, which is this asset trust.
Yeah, that's the investor. Okay.
And you have a serving agreement with Asset Trust, is
Yeah.
that right?
That's exactly correct, Your
Okay,
Honor.
Thank you.
Thank you.
Can
Yeah,
I-
there's another
I
one.
have one more question. If we were to reverse the decision here, what in your mind is the status of the case? What is the next event?
The status of the case is then it's ready for sale.
Thank you.
Thank you, Your Honors. We're asking
All
for
right.
you to reverse the
So,
trial court
Thank you
And
very much.
reinstate the judgment.
and reinstate the judgment. Yes, that would be part of the reversal. Yes, thank you.
All right, please take your seat now, and if you would, is it Ms. Brisson? Brisson? Bryson. I'm sorry. Please come on up to the podium if you would, please. And for the record, introduce yourself. You understand you've got 15 minutes. And we'll give you an alert before the 15 minutes is up. So please go ahead once you introduce yourself.
Good morning, Your Honors. Can you hear me?
Yeah, I can't, thanks.
My name is Karen Bryson. I
This helps a
represent,
lot, let me just say that. I don't know if you want one, but.
I
we've got-
represent myself as the appellee. I respectfully ask the court to affirm the trial court's dismissal of this case with prejudice or dismiss as moot for lack of capacity. The lower court acted well within its discretion and committed no errors, dismissing the case with prejudice and vacating the judgment. For Ditech's failure to comply to the court's July 5th order to prove who should substitute for plaintiff. Ditech's appeal makes another new attempt to litigate the case with false assertions unsupported by the record. Ditech has introduced new arguments for the first time in its opposition to motion to dismiss.
Do you mind if I ask you a question?
Yeah.
So after the judgment for foreclosure was issued and there was a period of redemption, which you actually still have that period of redemption for no sale, then you started getting notices from Shell Point as to the amounts that you owed, that they were the servicer for the mortgage and the note, and also notifying you that they had transferred the mortgage and the note post-judgment.
Right.
Was there any point of time that you got anything from Shell Point indicating that they were collecting on the judgment or collecting on the note?
No, and at this time, they're still sending mortgage bills to Sinks, who was dismissed in his name only, with new monthly amounts on them, and they're in the record.
And all those included an interest rate of 6.5?
I don't know what the interest rate is on them. I'm not sure.
Okay.
Okay. So Ditech's insistence that the court cited no authority or precedent is without merit. Although I may have presented confusion about the particular subsection of Rule 41, the lower court was clear. Quoting the court's decision, quote, "The court 7/5/24 specifically put Ditech on notice that it was required to prove who the real party of interest was, or it would be dismissed for failure to prosecute. The court is authorized to dismiss for failure to prosecute when a party does not comply with the court's order, and cited Deutsche Bank versus Panett, paragraph 18, and Senlar FSB versus Malafant, paragraph 5. Plaintiff failed to prove who the real party of interest was, and on notice, failure to do so would result in dismissal. The Vermont Supreme Court in Senlar made clear that a dismissal with prejudice vacates the foreclosure judgment and cites Malafant, paragraph 14. The citation of Panett, paragraph 18, says in part specifically cites Rule 41B and 41B3, saying it's essentially identical to Federal Rules of Civil Procedure 41B, noting there is no dispute that it can be dismissed with prejudice for want of prosecution, holding that it operates as an adjudication on the merits, and it's committed to the sound discretion of the court, stating involuntary dismissal under 41B operates as an adjudication on the merits and is with prejudice. And we know our rule is consistent with that in federal courts as well as many states. 41B3 says a dismissal under subdivision B, and any dismissal not provided for in this rule other than a dismissal for lack of jurisdiction operates as adjudication on the merits. And the court citation of Malafant, paragraph 5, says on the court's own motion in Malafant 5, it's similar to my case. The case has been pending since 2008, and despite repeated conferences, nothing has resolved. The court hereby dismisses the case for prejudice, for failing to prosecute by failing to appear at the scheduled conference. And the court citation of Malafant, paragraph 14, was in response to lender's failure to appear for a status conference. If the order did not vacate the foreclosure judgment, it would have created an irremediable legal limbo. The court had already issued an order indicating that further judicial proceedings would be required. Dismissal with prejudice is conclusive of a right of the parties that the suit had been prosecuted to a final adjudication. By dismissing with prejudice, the court ended all judicial proceedings and effectively vacated the judgment. Court gave full and forewarning, and counsel should be fully aware of precedent concerning the consequences of dismissal as they're the same law firm in Malafant and Panett. Failure to prosecute was a basis for dismissal under 41B. The sale and the confirmation order are mandated steps, so the case is not fully prosecuted. I did properly submit a motion to dismiss in the supplemental put in case 25 to 33, which was supported by evidence that plaintiff was out of business and conflicting evidence of others' claims of ownership. It is also evidence that the court had been instructing plaintiff since 2021 to resolve the party issue. There was a clear record of delay and willful disregard of the orders. Despite repeated instructions, Ditech consistently failed to acknowledge any evidence regarding the bankruptcy, dissolution, or conflicting claims of interest. The failure, coupled with my motion to dismiss and previous judge's orders, compelled the court to issue its July order. The court's directive sought to identify the proper party for substitution, a permissible and indeed necessary exercise in its inherent power to manage litigation. At that juncture, Ditech's silence regarding my evidence of his bankruptcy and dissolution effectively constituted an omission of those facts. Consequently, the court's order ultimately afforded Ditech another opportunity, as a direct grant of my motion to dismiss would have been a justified alternative. Having already initiated a motion for substitution, Ditech cannot now credibly argue that the court erred in ordering them to establish the proper party for substitution. Under Vermont Rules of Civil Procedure 25C, courts possess broad discretion to determine the necessity of substitution or joinder, guided by the specific circumstances of each case. While the rule typically facilitates substitution on motion, this framework.
I just have a question.
Yeah.
Get a fact. Didn't Ditech, it filed a motion to substitute, but then it withdrew it, right?
Mhm.
Okay, I just wanted to make.
Yes. It filed a motion for substitution claiming US Bank was the real party in interest, but I filed an motion in opposition showing the title defect, a lot of defects, so they withdrew it. Turner et al. Versus Ben and Jerry's, 223 CV 00099, 2024. Judge Rice dismissed the case for failing to comply with the court's order to file an amended complaint within 20 days, saying that, quote, Federal Rules of Civil Procedure 41B authorizes dismissal of an action when plaintiff fails to prosecute or comply with the rules or any order of a court. Where a defendant has not moved under 41B, a court may nevertheless dismiss a case sua sponte. Rule 41B does not purport to undermine the court's powers to dismiss for failure to prosecute, which is part of its inherent authority. Ditech's non-existence is the main thing in this hearing, and the evidence firmly established, and they conceded that they do not exist, and the winding up of the company was completed by the bankruptcy court. Their new one,
Wouldn't that be an issue in a sale proceeding?
even in court, I mean, how can they be in court? It would be an issue in the sale proceeding. It would be an issue in executing documents. Their winding down has been completed. They don't have any employees, so the court noted that they're not sure who Mr. Katz represents, and I mean, I don't know how he can represent them. They are not. It was firmly established that they were out of business with concrete evidence. None. I mentioned it in my brief where all the evidence was. And they're questioning now, it's late, it wasn't, that their existence, that the court didn't explain, do not exist. But it was not raised in their brief, but their own witness testified, I am aware that Ditech is no longer in existence. Ditech's counsel acknowledged they went through dissolution. The phrase does not exist was repeatedly used during the hearing. The court said, but Ditech no longer exists. And the issue I have is Ditech doesn't exist right now, so how can Shell Point? And I've noted in my brief all the places where it says does not exist, and they never spoke up or asked for clarification. And the same issue with real party and interest, it was said a whole bunch of times. They had numerous opportunities to request clarification, and they failed to do so. The court on my supplemental printed case, page 136 in the transcript, the court says, in order to have a real party in interest, we need someone who has the ability to enforce the judgment. And Attorney Katz said yes. And the term was used like all during the trial without any questioning of it. So their existence, the merger, I refer to my brief, the merger doctrine is not a law in Vermont. There's no precedent that supports it in Vermont. The mortgage liens are true liens. They're, you can't just say they don't exist. They're not real. They're in the court records. And I reference in my brief the legality, they're continuing liens. It was just a tactic to get around filing paperwork that they, that they didn't have, and they didn't, I don't know, it was just a tactic that the court saw that. And their canceled certificate of authority with Vermont, their assertion that they no longer require their certificate directly contradicts their prior registration and established legal requirements. No connection was established between my loan and Shell Point 1, Shell Point 2, or US Bank. The court ruled that Ditech submitted no evidence from the bankruptcy court that demonstrated Shell Point had the right to service the mortgage. No service agreement was provided. Transcript, page 9 and 10. The witness testified Shell Point relied on the power of attorney to service the asset. That didn't work. There was no evidence of any agreement between Shell Point, US Bank, and my loan. As noted by the court, other exhibits demonstrated numerous irreconcilable conflicting claims of interest, some of which are as follows. The uncontested evidence showed on 7, 10, 20, and 3,
You see that
22.
flashing light there?
Thank you.
How much time?
3 minutes. Thank you.
Yep.
Freddie purported to be the owner on 3/3/22. Supplemental printed case 130 conflicts with US Bank's claims of ownership of 12/19/21. Ditech's foreclosure trial position argued aggressively that it was not a Freddie loan. There's a lot more. The court noted them. They're in my briefs. None of the Shell Point letters, they all conflict with the assignments. And the big thing for me was I was always told that it wasn't a Freddie loan. I argued aggressively at the trial that it was because I'm trying to get it back on track, and they submitted something saying it wasn't. And they continue to say it wasn't. And I know I would have qualified for some of their refinance programs to get the loan back on track. And their new, right. Sorry, I'm nervous.
Well, you're doing fine. Go ahead. But you don't have much time left now.
Yeah.
So maybe, how much time?
Kelly has 1 minute, 30 seconds remaining.
Okay. To say that past judges didn't have any reasoning is just not, it's well supported in the record that there was many, many, many conflicts. I aggressively and persistently sought to explore Freddie Mac's foreclosure prevention programs. And arguing as US Bank as an investor is not the way that they call them in all the other cases. They just did that to sidestep getting around because their assignments nothing matched up. All the paperwork was a mess. And
You want to sum up?
yes, so thank you, and I respectfully request that you affirm the lower court's decision or dismiss for lack of capacity. Thank you.
Thank you very much. Does the appellant have time?
Appellant has no time remaining.
All right, please call a conclusion of the hearing.
That concludes today's hearing.